Well, hey, I hope you had a good lunch. I hope it tasted good. It did for me. So, yeah, it's always a vital part of the day. An interesting part of the day is the lunchtime. So, gather around. We're going to get started with our next speaker here in about 2 minutes or so. So, if you could get back to your seats, we have a very interesting topic, a couple of topics coming up here that are going to be very interesting. So, gather around. About 2 more minutes, we'll get started. You okay with it?
All right, thanks, Wilmer. I'm going to just do a quick introduction here, and then we're going to split up the topic. So the topic for today for us is going to be a capital gains tax as well as inheritance tax, which of course is very riveting after lunch, so nobody's allowed to fall asleep. Nap time will be later. We'll try to keep it as spicy as we can. My name is Ashley Glick. I'm, as Wilmer mentioned, one of the partners over at the firm. I worked at the firm as a paralegal for 4-ish years, something like that. Went to law school and came back as a practicing attorney. I've been there for going on 7 years, and happy to be back because I went to law school at Villanova, came back to our community, definitely having more fun here in the real estate side. And Tom was my boss at one point, and now we're partners, which is very exciting for me.
Alrighty, good afternoon, everyone. Like Ashley and Wilmer said, my name's Tom Fanning. I work with Ashley down at Glick, Goodley, Deibler, and Fanning. Helped co-founded that office back in 2008 or so I've been working in New Holland for about 20 years. Ashley's and my practices are very similar, so we focus on real estate and estate planning and administration work. So on the real estate side, we have a title agency. We hold a bunch of settlements. We get to work with Beiler-Campbell a lot at auction and on the brokerage side. And on the estate planning and estate administration side, that means we spend a lot of time drafting wills and powers of attorneys, estate planning documents, and then helping people administer estates after they're gone. I mentioned that because those two topics are exactly what we're talking about today and the things that we're dealing with every day in real estate or estates. So like Ash said, we're talking about capital gains and inheritance taxes today. I'm going to try to take maybe just about 10 minutes to kind of give you the framework for both of those tax structures, and then Ashley's going to tell you how you might be able to get out of some of the potential inheritance taxes, and then that should flow well into our partners. Patrick and Sam will be in an hour or so talking about 1031 exchanges, so talking about how to potentially defer some of those capital gains taxes. So I'll start with inheritance taxes. Inheritance taxes, just kind of the vernacular first. When we say inheritance taxes, we're talking about a very specific tax. Sometimes you'll hear people say inheritance tax and they're just generally talking about death taxes. So death taxes are any kind of taxes on assets, so not on income, but we're paying a tax on stuff simply because we passed away and we own that stuff still. So when we're talking about inheritance taxes, we're talking specifically about Pennsylvania's inheritance tax. You'll also hear people talk about estate taxes. Some states have estate taxes, some states have inheritance taxes. There's a technical difference between the two that doesn't really matter. But the important part is that Pennsylvania has an inheritance tax. The federal government has an estate tax. So here in Pennsylvania, if you hear us talking about estate taxes, then we're probably talking about those federal taxes. So like I said, an inheritance tax is a tax on assets. It's essentially, if you were to take a snapshot of someone's balance sheet on the day that they passed away, we add up the total value of all of their assets, we subtract all of their liabilities, and whatever their net worth was on the day that they passed away, that number is subject to Pennsylvania's inheritance tax. The tax rate depends on who the beneficiary is receiving those assets. So there's 4 different tax rates. There's a 0% tax rate that applies for spouses and charities. So if you pass away and you leave everything to your spouse, as most people do, there's no inheritance tax to pay when one spouse passes away. When you pass away without a spouse, if you leave everything to lineal descendants, which usually just means children, but it could be anyone up the line, down the line in the family tree. So children, grandchildren, parents, grandparents, that tax is 4.5%. When you leave things to siblings, the tax is 12%, and if you leave things to anyone else, then the tax is 15%. who pays the tax? So technically, the inheritance tax is levied on the individuals that are receiving the tax. But as a practical matter, most attorneys, and it's Ashley's and I's practice, that through the planning process, it's something to consider, but we're usually suggesting that when people draft wills, they include language in their will to direct their executor to pay all those taxes off the top of the estate. So that way, when the beneficiaries receive their inheritance, the inheritance tax has already been paid. When does it have to be paid? The inheritance tax return is due 9 months after somebody passes away, and the inheritance tax return is in the lawyer's purview. So CPAs handle the income tax returns and a decedent's final income tax return. The attorneys handle the inheritance tax returns, the estate tax return if we have to file one, and any income that has to be picked up from the estate while that's open. You have 9 months to file that return, but if you file it within 3 months of when somebody passes away, or if you just pay some estimated inheritance tax within 3 months of when somebody passes away, state likes getting their money early, so they give you a 5% credit on any amount that you've paid within those 3 months. Again, usually executors are working with us and we're helping them come up with estimates to pay that. Some common questions. Do you have to pay inheritance tax if you own property in trust? Yeah, you generally do. So if you transfer everything that you own into a revocable living trust and you keep control over those assets and benefits over those assets, then a trust is not a vehicle that gets you around inheritance tax, despite what you'll sometimes hear. Some of the reasons that you might hear those things is that, remember, we're talking about Pennsylvania law here, so 50 different states have 50 different laws on these things, so in some states that might not necessarily be the same case. Can I give everything away to get around inheritance tax? Yeah, but you need to plan ahead to do that, and there might be some negative ramifications of giving things away that we'll touch on later as well. But you have to remember, if you are going to give anything away and hope not to pay inheritance tax, you have to give it away at least a year before you pass away. So there's a 1 year look back. Otherwise, on our deathbeds, we would all just look at our kids and say, I give you everything, and then we would die with nothing and nobody would ever pay inheritance tax. So that's how Pennsylvania gets around us doing that. So that's the basics of inheritance tax. We'll save some time for some questions here. About the federal estate tax, the reason I'm not going to spend more than the next 20 seconds talking about that is it very rarely applies. So there's a $15 million exemption as of 2025 on the federal estate tax. So unless your estate is greater than that number, then we don't talk about federal estate tax returns. If you're married, you can double that number. So with some planning, you can actually increase it to $30 million pretty easy. If you know anybody that's in that tax rate, it's a good problem to have, but it's also a very high tax. So in Pennsylvania, while we're usually paying taxes at 4.5%, if we have to pay federal estate taxes, then those rates range between 18 and 40%. So at the top end of that range, about half of what you have over the exemption amount could end up with the federal government. All right, so that's half of our presentation on inheritance taxes. The other part is capital gains taxes. So what's capital gains tax? The capital gains tax is a tax on realized gain from an appreciated asset. So stereotypical example, if I buy a baseball card in 1964 and I buy it for $1 and that baseball card today is worth $100,000 and it's sitting at home in my drawer, do I owe any capital gains on it? And the answer to that's no, because even though it's appreciated, I haven't realized any of that gain yet. So if I sell it, then I realize the gain. I have a $100,000 purchase price. I paid $1 for it. So that $1 is what we call our basis in it. And I have to pay capital gains tax on $99,999. How much is the capital gains rate that you pay? I can't answer that because it depends on what your personal taxes look like. So it varies. Anywhere between 0 and 20%. And when you add an Obamacare surcharge onto it of 3.8%, then it can be anywhere between 0 and 23.8%. So we're talking about potentially some big taxes there on the Fed side. Pennsylvania picks it up the same as they pick up ordinary income. So capital gains rates in Pennsylvania are that 3.07%. How's it calculated? I touched on that, and we don't really have a lot of time to go into the weeds on this, but when you sell something, your capital gains in general is your sales price minus what you paid for it. There's some depreciation issues that come in there that can change that. But in general, that's what the capital gains is. So imagine instead of my baseball card, I bought a 4-unit apartment in Lancaster in 1994. It was $100,000. Got a good deal, $25,000 a door, and today it's worth, say, $600,000. So do I owe capital gains on it? No, because I still own it right now, so I haven't realized any of that gain. But if I sell that property, now I have a sales price of $600,000. a basis, again, we're being simplistic here, but call it $100,000, and that $500,000 of gain, I realized I have to pay capital gains on it. Like I said, Patrick and Sam will be here this afternoon to give you a potential 1031 strategy to delay some of that gain. So I'll just take 30 more seconds here and kind of tie together some capital gains and inheritance tax issues. If I, instead of selling that property, if I simply hang on to that property and I pass away with it, let's say I leave it to one child after I pass away, property's still worth $600,000. Pennsylvania's inheritance tax applies because I owned it when I passed away. So I'm paying, or he's paying 4.5% of the $600,000, which is $27,000 or so of inheritance tax. About once a month, Ashley and I have a conversation with the client where we sit down and the client says, I don't want to pay $27,000 of inheritance tax, or I don't want my child to have to pay $27,000 of inheritance tax. Should I go ahead and transfer that property to them while I'm living? So they know the inheritance tax equation. They want to save the $27,000. A lot of times, the reason that doesn't make sense is they haven't necessarily thought through the capital gains side of the equation. So stick with me for just a minute. This gets a little bit into the weeds here, but if I transfer a property to a child while I'm living, and remember, I paid $100,000 for it, they get my $100,000 basis. So even though they didn't pay anything for it, you saw it in the Sunday paper, it said I transferred it to them for $1. It was really nothing. They still get my $100,000 basis in it. So let's say I pass away and then they sell it, they're paying capital gains on $600,000 minus the $100,000 basis that I paid for it. So $500,000 a gain, let's say they're at 20%, that's a $100,000 capital gain tax bill. There is one way that you can avoid anyone ever paying the capital gains on all of that appreciation, and that is to pass away still owning that asset. So if anybody's ever heard of stepped up basis, then that's where this concept comes in. So the conversation we're having with that client is, what do you think the child's going to do with it after you're gone? And if it's, well, I'm going to sell it, and it's, well, let's think about that, because if you hang on to the property and they get it through your will and it's worth $600,000 at that time, they get a stepped up basis to $600,000, to whatever it was worth on the day that you passed away. Even though they didn't pay a nickel for it, they're treated as if they paid what it was worth when you pass away. So then if they sell it, and let's say they hired Beiler-Campbell, so they got a very good price at the auction, and it brought $640, even though it was only worth $600 when somebody passed away, then that $40,000 is what they're paying capital gains on. So you can see, by letting them get it when they passed away, we wiped away all of that $500,000 of a gain that built up during someone's life. Even if they hung on to it, at some point they sell it for $1 million, they're still only paying the capital gains on the million versus the $600,000. So that's kind of the capital gain side of the equation that a lot of people don't necessarily see when they're thinking through those inheritance tax issues, but both of those issues are very intertwined. So again, those are kind of the basics. I know it was quick. We'll try to save a little bit of time for questions, and Ash is going to talk to you about what you really want to know, which is whether your children are going to have to pay inheritance tax on agricultural land that you own.
Thanks, Tom. So I have a few exemption points that I'm going to mention. When it comes to inheritance tax, oftentimes when we meet with clients will say to me, well, everything I owned during the course of my life was taxed already, so why am I being taxed again? All I can say to that is, you're correct. This is technically double taxation. And Tom had mentioned before that each states treat this inheritance tax area, I guess, differently. So for Pennsylvania, this tax came into play around in the 1800s, early 1800s, and it's kind of stuck with us. There's about 5 states in the US that keep an inheritance tax on estate administration, and we happen to be one. So you often hear people saying, I'm out of here, I'm retiring in Florida. That's because they don't have inheritance tax. So it's warmer and you pay less tax, and we should all go there. But if you're stuck here in Pennsylvania, I'm gonna walk through just a few of the exemptions that do come into play. And I'm going to end with the ag exemption. I know everybody here is probably pretty interested in that. That's going to apply the most, I think, to this crowd. So I'll try to just quickly go through. Tom and I won't be here for the question and answer session. So as he mentioned, we have some time built in at the end here. You guys can ask us specific questions. I believe our partners are staying. At least one of them is staying, so you can also pepper him too if you'd like. The first exemption I wanted to cover is something called the family exemption. So if you pass away residing with an immediate family member, that family member is entitled to what the state is calling a family exemption. So it's assumed that if someone is residing with you while you're passing, they're caring for you in some way. The monetary amount that they've assigned to that exemption is $3,500, which is, I think, could be a joke, but who knows? I mean, every time it comes across the floor, it's revisited, it hasn't been raised. I think everybody here knows if you're caring for a family member who's passed away, there should be a few extra zeros on the end of that. But what we have right now is just that $3,500 exemption. Practically speaking, the way that it works is a check is cut for that amount out to the family member that cared for you at your passing, and then it's a deduction, so it's not a taxable amount. There is the charities, which Tom mentioned briefly. So if you have any sort of charitable bequest in your will, that gift out is going to be at 0% tax. So that's a deduction for the estate. I often hear people say, well, I tithe during the course of my life. I don't really feel like it's necessary to give through my estate. And I understand that argument, and it does make sense. It's not necessarily an argument. I guess it's more of a position. But for us, we're trying to get your tax bill down as much as possible. So we're working really hard for that. And we like to see charities. Anytime there's a charity, the AG is involved, so it's a little bit of extra steps for us on the administration side, but it does help you guys. Well, you won't be here, but it would help your family members with the estate process as far as taxes and also deductions. There is a family-owned business exemption as well that can come into play. So if you pass away owning a business and you've given that business out to family members, if your family continues to run that business for at least 7 years, that the value of the business is exempt as long as the business itself is not valued in excess of $5 million. So some restrictions there: the business has to have been in operation for at least 5 years. It has to stay with immediate family. It has to actually pass through the will. And then what we do when we file that inheritance tax return that Tom mentioned, we'll claim an exemption on the full amount of that business up to that $5 million. So if the business is valued at $5,001, it doesn't qualify for the exemption. But the purpose here is to kind of take those small businesses that we own at passing and then afford an exemption so that the businesses don't have to be sold or liquidated just to pay a tax bill. And practically speaking, on the back end, whoever steps into that role to run the business is required for that next 7 years to send in a tax return. Has to show that the business is in operation, that it's income producing, and then at that 7th year mark, that's it, you're good to go. You can do what you'd like with the business. If the business were to cease operation within that 7 years or is liquidated or changes ownership and the new owner is not a family member, then that tax is owed back in. I'll just put a little plug here too. Every once in a while, if we're meeting with people and we have businesses that own real estate, you can bifurcate, you can separate the two out. So oftentimes we'll say to people, hey, your real estate is valued at X, your business is valued at this much. Let's set up two separate LLCs. Let's try to get two separate exemptions here. So the state does allow you to do that if you can parse that out. Just because sometimes real estate, if you have commercial property, it's going to quickly drive the value of that business up past that $5 million threshold. Okay, so ag. So there's an ag exemption that is relatively new. It came out in 2012 in Pennsylvania, and for us attorneys, 2012 is relatively new. So there's not a lot of case law. We like case law. We like when attorneys before us get sued because then we know what we can and cannot do, and it kind of breaks down the code for us and it becomes more specific. So the ag exemption was put in place to encourage family farms to stay in the family. And on the flip side, to encourage any sort of ag operation, try to discourage farms getting chopped up. What Pennsylvania was seeing was that estates, people were passing away, the value of the property is very high, and then the family members can't afford to hang on to that property because they can't afford the tax. And so it was forcing farm sales. So what they've done is they've set up something called the AU exemption. And I would say it's a little bit, it's a very boring read, so you don't have to jump into that. But as you read through, it's not very clear on the prongs that you need to hit for the exemption itself. So I hope I'm not speaking out of turn, but what we do is we file these. We are pretty sure we're right. The tax savings is very high, so even if it's 4.5%, if you have a $3 million farm, it's worth it for us to say, hey, let's file this exemption, let's see if it sticks. So with that being said, the exemption is split into two parts. The first is the business side. So if you have a farm, it's an active farm, it's income producing, it's ag related, even if it's leased out. So maybe it's not farmed by an immediate family member, you have a third party in, it can still qualify for the business of ag exemption. So what we would do is we get together, we take a look at the value of the buildings, we take a look at the commodities, what's being produced, what the service is, who owns what, and we file that exemption on the business side. And then there's this wild hanging exemption for what we call farm use other. And so the way that the tax code reads, it says, all right, if you have a farm and maybe it's open to the public to come in because you have a pond and there's fishing there, you can take that exemption. If you have some trees, you can try and take an exemption there too. If you have ag produced there, or maybe you don't have any ag there, maybe it's just flat ground, but at one time it could have been leased or it was leased. There's even a provision where it talks about the forest reserve. If you have a certain amount of acreage and the trees are a certain size, you can take an exemption. So you can see for us attorneys, when we sit down with our clients and we're talking about estate administration, we say, hey, look, I think this could work. We're gonna go ahead and file this. I'll use my most recent one. I sat down with the executor. The farm, it was mostly tillable. There was a third party that was tilling, but then there was a house and there was a tenant in the house. The tenant was not doing the farming. So what we did was we took a look. There was also trees. So there was tillable land that we took an exemption on. The trees were mature. They could have been timbered, so we took an exemption on the trees. The language was a little bit confusing about how much land needed to be there for the trees, but I said, hey, look, we're going to be saving about $140,000 in tax. Let's file this. Let's see what happens. So we went ahead, filed it, and it went through, which was great. But for us, we are always up front saying it's a little bit of a gray area. We, of course, are going to do our best to kind of parse through this and see what fits where. Our goal is to have the least amount of tax paid and also to preserve farms, of course. So Lancaster County, I think, is leading the way on this exemption. I looked through, there are a few that were filed in the last year or so in Chester County, but it's mostly on the Lancaster side. So with that being said, I'm sure there's lots of questions with the ag side of things, and we'll try to answer them for you the best we can. But just with the understanding that's relatively new exemption, we're working our way through it. The tax, I think it's very exciting to sit down and put the pieces together, but you guys might not be as excited, but you could be excited about the tax savings. This is the most exciting exemption for inheritance tax, I think, that Pennsylvania has afforded us. So with that, did you have anything you want to add? Mm-hmm. All right, if you guys have any questions, what time are we at? We have a minute. Quick. Yeah.
My mother passed in May of 2012. And if that law came into effect, it was about a month after her death. The farm has been in the family for 6 generations, no changes in lineage, and we had to pay the taxes because she died about 30 days prior to that bill.
Mm-hmm. Yeah, isn't that interesting? You're right, so it was May, I actually wrote it down.
2012.
Yeah. So her mother passed away right before the exemption came into play. So they ended up having to pay the tax. It was a statement. So everybody make sure you plan appropriately when you're going to pass per exemptions. It'll be in your best interest.
And what's the form called?
So it's called an AU exemption form. And you can go onto the department website. They have a pretty thick instruction packet, but if you can work your way through it, it will direct you. And you'll be familiar with the property itself, so it will help you kind of work your way through.
Yeah.
You were saying about Pennsylvania tax and in Florida, you don't need to pay that. How about if you have a friend in Florida and you live in Pennsylvania?
Yeah, really good question. So if you take real estate away, then the state that you're a resident of is where you're going to pay inheritance tax on everything that you own. So it doesn't matter, let's say I'm a resident of Pennsylvania, I have money in the bank and my bank is a Florida bank. I'm still paying Pennsylvania inheritance tax on that. Real estate's the exception to the rule. So if I own real estate in other states, the real estate is subject to whatever inheritance tax exists or doesn't exist in that state. Similarly, if you move to Florida to get out of paying inheritance tax on all of your non-real estate assets or Florida real estate that you own as well, and you keep a property up here in Pennsylvania, well, even though Florida doesn't have an inheritance tax and you're a resident of Florida, you're still going to pay Pennsylvania's inheritance tax on the Pennsylvania real estate. I should have repeated the question, but you probably surmised that it had to do with if I live in one state but own real estate in another state, what state law am I subject to the jurisdiction of? And the answer is both of them. Yeah. And I think I saw some wheels spinning when Ashley was explaining the ag exemption. You might kind of see how that flows into the capital gains stepped up basis benefit as well, that if you play your cards right, then you might be able to own a farm, hang on to it till you pass away. That way it's been in the family for a whole bunch of years. You might have a tiny little basis for it, and fair market value for it is up here. Remember, if you pass away with it and leave it to your children, all of those gains get wiped away. So they get a stepped up basis to actual fair market value. If we get an appraisal on it and it's $5 million, even though nobody's ever paid in the family more than $700,000 for it, somebody's getting a stepped up basis to $500,000 and wiping away all those gains. And then if you can couple that with the AU exemption, so you're not even having to pay the inheritance tax to get that benefit, then obviously that can be huge. Like Ash said, there are a ton of gray areas still in those AU things, but what we do know is that for kind of the typical scenario where you do have a farm operation and you do leave it to children and they do keep it in ag for more than 7 years, then that's clear. There's no gray area there. So they're going to get the exemption. It's when they sell it before that, or it's not an actual farm operation, or something else is going on that we're still trying to figure things out. I think we're out of time, Chris.
You want to address the residential allocations? 215, 500, Val?
Yeah.
Residential allocations?
Sure.
Oh, yeah.
Yeah, so Chris asked if we touch on the residential gain exclusion. So Section 121 of the Internal Revenue Code says that if you live in a property for at least 2 of the last 5 years, you used it solely as a residence, you didn't use it for a business, and you